皆さんこんにちは。 NGB 意匠ワールドツアー第5回ブラジル編のナビゲーターを務めます中村智則と申します。さて、各国の意匠プロフェッショナルから意匠の最新情報をヒアリングするこの企画、第5回目の本日はブラジルのダネマン事務船事務所にお話を伺います。本日のテーマはブラジルの意匠実務についてです。それではスタート。まずはじめにシニアパートナーのアマラルさんよりご挨拶をいただきます。Mr. Amaral, could you share with us some brief information about your office?
Hello, my name is Luiz Henrique do Amaral. I am the senior partner of the law office DANNEMANN, SIEMSEN, Bigler, and Ipanema Moreira. We are an IP specialized firm that was originally founded in Rio de Janeiro, Brazil in 1900. We are completing this year 120 years of existence in the IP area. Our firm has basically 4 offices, one in Rio, the other one, which is the main headquarters, the other one São Paulo and Brasilia. And for our international work in Latin America, we have a hub office in Uruguay, in Montevideo. Our firm has had a long tradition in IP in Brazil and in Latin America as a whole, and we now count with 72 partners, 200 lawyers, 80 industrial property agents, distributed in all these law offices. Our firm, as I said, is specialized in IP. It's the longest IP firm in Brazil in existence, and we are very proud to be an active and competitive law firm for our clients. It's a pleasure to record this video for NGB, and I hope we can work together. Thank you.
Thank you very much, Mr. Amaral. Next, we would like to talk to Mr. Ehlers. Mr. Ehlers, please explain the unique characteristics of the examination of the industrial design and enforcement in Brazil.
はじめまして、私は Marc Ehlers です。私のダネマンの弁護士とエンジニアです。どうぞよろしくお願いします。I'm sorry for my poor accent in Japanese. It's very hard for me, but I hope you can understand my bad Japanese. I will have to talk to you in English because it's easier for me. And today I'm going to share with you some information about industrial design registrations in Brazil. We are going to share with you some aspects in order to have a smoother procedure in Brazil and on how to use your designs in our country. But before that, I would like to thank NGB very much for sharing with us such opportunity in order to inform you about our practice. We are very honored with that. And what you should perhaps have in mind is that Brazilian designs are usually only formally examined. They are not examined on the merits. So this means from filing to grant, it's just a couple of months. Before that, Brazilian designs registrations are not published, but because publishing comes only with corresponding grant. So nowadays, from filing to grant, it's around 2-3 months. It's very fast. Until recent past, it was around 2-3 years in order to retrieve a corresponding registration from the Brazilian Patent Office. And this means that the Brazilian Patent Office did their job by facing the huge backlog that they have at that time. Examination on the merits of industrial design registration can only be requested by the title holder of the corresponding design. And sometimes it's important to have the examination on the merits, especially when you are trying to enforce such design registration against third parties, for example, in a lawsuit, and you want to have a preliminary injunction to be enforced at the very beginning of the suit against the infringer. And by having the examination, a positive examination on the merits from the Brazilian Patent Office, the chances of obtaining a preliminary injunction is greater. So, what's important to have in mind is that you can pursue your industrial design registration in very different ways in Brazil. For example, if there are infringers in a trade show, you can sue them, you can send warning letters, you can retrieve information about potential infringement in order to see the measures that can be pursued afterwards. You can also have border measures in Brazil and other ways of enforcing your rights in Brazil. We will be glad to share with you some more detailed information for your specific cases you might have in Brazil. And also a very important aspect that you should have in mind is that industrial design registration sometimes can be enforced together with other rights the patentee may have. For example, trademark, unfair competition practices can be alleged by against the infringer, and you can, in some occasions, have a bundle of different IP rights in order to enforce this against the infringer. And thereby having a registration in some cases is very important because it shows to the judge that this right is not only being infringed by the infringer in one aspect, but by a bundle and a more extensive way in Brazil. So basically, you should have in mind that registrations of designs are very easy to obtain in Brazil when you consider formal aspects, and the injunction and enforcement against third parties, it's very smooth and clear to be used in courts against third parties. どうぞよろしくお願いします。Thank you very much.
Thank you very much, Mr. Ehlers. We are surprised that nowadays it's around 2 to 3 months from filing to grant. Next, we would like to talk to Mr. Carstens. Mr. Carstens, please introduce us our latest design practice in Brazil.
はじめまして、私はフレデリコ・カーステンスです。どうぞよろしくお願いします。Since the publication of the industrial design application in 2018, the BRPTO has achieved success in reducing the time window between the filing and granting of industrial design applications, dropping from 12 months to 2 months on average. Recently, the issuance of office action has taken place in just 1 month. This speed proves to be strategic for protection in Brazil. With the advent of the manual, the BRPTO started to follow clear guidelines for examination and filing requirements, reducing setbacks and conflicting personal opinions from the examiners themselves. The manual made clear some previous doubts, for instance, the presentation of drawings with dashed lines. Currently, depending on the object claimed, the applicant may have 2 possible scenarios: filling all dashed lines or remove those dashed lines, provided the remaining object subsists as a separately produced object. Please note that such amendments should be made only upon examiner request by means of an office action. Considering this, there is a particular issue that must be observed in the case of filing out an industrial design application in Brazil. The strict understanding of the BRPTO as to the exact similarity between the images contained in the priority document and those contained in the application. Unfortunately, applications submitted with drawings slightly different from those contained in the priority document recently led to a loss of priority. Therefore, we strongly advise our clients to apply with drawings depicted in an exact manner as in the priority document and wait for the examiner's opinion. This strategy aims to maintain the security of the priority claim, since any drawing amendment made under BRPTO request due to the presence of dashed lines, for instance, does not affect the priority claim itself. Another important advance was the implementation of a digital communication channel with the BRPTO, where is it possible to resolve doubts about the office actions before submitting the answer, making communication more transparent and increasing the success rate in meeting the examiner's request, thus reducing the chances of a rejection or the issuance of a further office action. An important issue: Brazil is not yet a signatory of the Hague Agreement, but studies are being carried out in this regard. We are at your disposal for any further clarification regarding the filing process for an industrial design application or any other IP matter.
Thank you very much, Mr. Carstens. We really appreciate you, Mr. Amaral and Mr. Ehlers. インタビューは以上となります。本日はブラジルにおける最新の意匠実務についていろいろと学ぶことができました。もしブラジル意匠出願について何かご不明な点などがございましたら、私たち NGB にお気軽にご相談ください。皆さん最後までご視聴ありがとうございました。この動画が役に立ったと思われた方は、ぜひ高評価、チャンネル登録をお願いいたします。次回は第6回アメリカ編です。お楽しみに。